the High Court is proceeding with a criminal trial. Now, this is in the case of Rex versus Shongwe. Rex, that means king. So, in other words, it's the state against a person who's basically violated the community that should tell you that, this is a criminal matter. Before I proceed, hi, my name is Vilimile Gumete. I'm the host of the Nkantolo podcast, Nkantolo, Nkantolo podcast. Nkantolo simply means court. Now, in this particular court, the High Court, in this particular case, the High Court is proceeding with a criminal trial, that being the matter of Rex versus Shongwe, which has been, ongoing for the last 2 years, well, at the time in 2021. So Mr. Shongwe's lawyers are in court, but he requests to speak with the judge directly. The judge hears him on a complaint that he's basically suffering serious humiliation and differential treatment to other inmates in the facility where he's held, that being the Matsapa Correctional Facility. So he asks to be placed in a different correctional facility where, this thing that he's complaining about will basically not continue. So the court adjourns briefly for the judge to confer with all the lawyers. And having done so, the court then resumes and makes an order that, the correctional services must immediately detain Mr. Shongwe at a different facility. So the commissioner, who is basically the person who's in charge of all the facilities, is displeased with the court order. So she brings an urgent application to stay it, coupled with an application that the order actually has to just be rescinded or reversed, if you will, because it is her exclusive prerogative as superintendent over all correctional facilities to retain complete oversight on the inmates held within those facilities. So in her papers, she says, well, I'm the one who chooses. Well, if I may quote, I choose where they ought to be kept. With due respect, no one has the right to usurp these powers without affording me a hearing. End quote. So a number of submissions are made by her, in the transfer process. And she tells the court that intelligence actually shows that there are foreign individuals which have been hired to execute or to assist Mr. Shongwe in the execution of effectively what would be a prison break. So in response to this, Mr. Shongwe opposes the commissioner's rescission application on quite a number of bases, including that the commissioner relies on hearsay evidence that she has flouted. Firstly, that she's relying on hearsay evidence, then also that she has flouted the High Court order, and thus she is now even approaching the court with dirty hands. So the court actually considers Mr. Shongwe's position and agrees with him, and then dismisses the commissioner's rescission application. Then, dissatisfied with this finding, the commissioner then appeals on some 11 grounds to the appellate court, that being the Supreme Court of Eswatini. So Mr. Shongwe opposes the appeal, and now we basically have some insight into, some of the salient facts of this case. So let's see what questions then arose for the court to resolve in its majority judgment. So firstly, these are just some of the questions, that we have to consider. If indeed the commissioner has an order that tells her to relocate Mr. Shongwe, can she disregard it? So that was one of the questions which the Supreme Court was concerned with. In other words, should she not abide by the order until it has been rescinded or set aside? So let's consider with this question whether or not the court was actually supposed to reach its order having considered, sufficient evidence instead of just hearing Mr. Shongwe's account in court. So the appeal justices, they usually sit in 3 in the Supreme Court. The appeal justices from the onset highlighted that incarcerated persons have constitutional rights to be held with dignity and not to be subjected to torture. Well, if you're watching this on YouTube, you can always just go down in the description below and find the full reference and the link to the case on eswatinili.org. That's eswatinili.org. But the link is right down below if you're watching this on YouTube. and then you can just kind of have a read of the entire judgment. Well, the appeal justices from the onset highlight that the incarcerated persons have constitutional rights, uh, which should be held with dignity. Um, that they should be held with dignity, and that they should not be subjected to torture. The Supreme Court, therefore, held that the High Court should have heard oral evidence so that it could make an informed decision. So the majority judgment was therefore that the appeal, partially succeeded, and that the matter was referred back to the High Court for oral evidence, to be considered. So now we know what the position of the court was in the majority judgment, which basically makes up, the decision in its totality. But then let's also consider the minority judgment, which interestingly made up for the majority of the page numbers of the entire written judgment. Well, the learned justice's chief concerns, the justice that penned that particular minority judgment, that justice's concerns basically start, with the doctrine of clean hands. So what Mr. Shongwe tells the court is that the commissioner indeed complied with the order just for a couple of weeks. In other words, she placed him, in an alternative facility in Manzini, and then later changed course, having him placed right back at the Matsapa facility where she had been, where he had basically complained, of an unfair or differential treatment, all the while bringing an application for rescission to court. So in essence, Mr. Shongwe's gripe is that the commissioner basically came to court with dirty hands by disregarding the High Court order. So Mr. Shongwe's counsel argued that the commissioner had no regard for the rule of law and should not be granted any redress by the court until she basically, purges or fixes the contempt which he alleges the commissioner finds herself in at the time. So the appeal justice who wrote the minority judgment goes on to then offer, the following proposition. Court orders can be breached. Then he makes the example that it would be justifiable to breach the court order, for example, if the prison facility actually caught fire. The minority judgment seemed to be saying, do not just reject the one who comes to court with dirty hands. Consider first her reason for disobeying the court order, and only then can you accept or reject the reason. So the commissioner had in any event said on her papers, the prisons are locked at 4 in the afternoon. And then I, as the commissioner, only received the court order at like 6:30 in the afternoon, or rather in the evening, if you will. So the Supreme Court in its minority judgment found this to be a reasonable explanation. And so turning to the matter, the manner in which the order had come about, the court then said the order did not really afford the commissioner enough time to prepare for the transfer or for the move. And so the first line of attack should have been to order that Mr. Shongwe must not be ill-treated anymore. Only if this did not work would it have been sensible to then order that Mr. Shongwe be moved. What made it worse, these are all the findings of the minority judgment, made in the minority judgment. What made it worse was that Mr. Shongwe made an unsworn statement in open court. In other words, he never took the oath. He was never cross-examined on basically what he was submitting to the court. And so it is unfathomable how the High Court could have known that he was even telling the truth. So if you do have your own thoughts about, this part of the judgment, do leave a comment. Anyway, having considered all of this, the Supreme Court then basically held that the real issue was not clean or dirty hands. It was an application to stay the order, read together with the application to rescind and set aside the order that basically said that Mr. Shongwe had to be moved. So the commissioner's appeal then succeeded, and the High Court order was set aside, and the court basically made no order. as to costs. Usually the party who loses in a court battle, if you want to call it that, has to then reimburse or pay the costs of the other party. Sometimes if it can they can actually be paid by an attorney, but that's for another short, a 30-second short, where we can just have a brief conversation about the types of costs that are usually ordered in a court of law. So I would say that this case, makes for an interesting read. In any event, I'm hoping to get your thoughts, because I know that this kind of content is not necessarily only interesting to people who are in the legal sphere. It's interesting to basically anyone who's out there that just wants to read a judgment. Well, that's what we're doing in season 1 of the Nkantolo podcast. Well, this is episode 8, I believe. And we just look at judgments that come specifically from the Supreme Court. So do stay tuned in. Check out if you're on TikTok, if you're on Facebook, Vilimile Kumete, if you're on YouTube, just find Nkantolo podcast and you will find this video there. So if you think that justice was served in the end, let me know. Punch in something in the comments, but obviously I don't want you to forget to like, subscribe, share, comment, do the things. And until next time, thank you for listening.